Joining us now is Amar Patnaik ji, and Amar Patnaik ji, namaste. It's once again we are talking about data protection. The last time we spoke, it was around personal data. Now it is data protection bill. So, and more than about 140 hours of discourse and about 200 amendments that have been suggested, if I remember correctly. So the conversation has come a long way. Can you take us through the entire process and how it has evolved so far?
You see, the bill was introduced in later part of December 2019, and after the very few initial interactions with the ministry and a few witnesses whom we had invited, then the corona struck us, and unfortunately, Meenakshi ji also got down with corona. So till about July, we couldn't really work much. But after July, despite the wave being there and none of us having been vaccinated, we went on, and I give full credit to all the committee members. We are having meetings almost every week from July 2020 onwards. And as you would have seen, I think there are 78 or 79 sessions that we have had.
Yeah.
And so I say that the kind of interaction or the kind of deliberations that has taken place in this joint committee would probably not have been made by any parliamentary committee, standing committee or otherwise during the entire history of the parliament. Therefore, a lot of thought has gone into this bill in all its aspects. We have, in fact, done clause by clause analysis of the bill which was introduced. And what you see today is actually a thought which is not just of the members, but elaborate discussions with academia, with lawyers groups, with activist groups, with the people who are affected. That is, let's say, in case of the big tech, the Amazons, the Facebooks, the Twitters. So I think the consultation in this process has been really elaborate. I really would be surprised if any other country would have done it. So I think that has come out. So, the process has taken a long time. What you're going to have now has had elaborate discussion at parliamentary level with all stakeholders. There could always be things, which, would not be satisfactory to all, will satisfy all cross sections of people. But you see, the most elaborate legislation is the EU GDPR, which was introduced in as late as 2018 by the EU. So we are not doing too bad. In fact, we did quite well. We brought on the good practices in the other countries which have similar or equivalent laws. So what the final bill is going to be introduced in the first week of December could be something which people would actually appreciate for the kind of content and the kind of rigor it has gone through. But as I said, there would still be some who would have wished some more things should have happened. It's an evolving process. I think as the data protection regime, individuals' knowledge and awareness of their personal data and non-personal data, both, it gets more evolved. They would themselves probably call for changes in the act, and that would happen. And as regards your question relating to personal and data non-personal, it was a conscious decision which was taken, and after wide consultation, it remains to be seen. This is the view of the committee, which will finally be coming up. It is, of course, to the House to decide whether they would like to have a separate or they would like to have combined as it is. Mind you, the House had the bill which was introduced in the House was just the personal data protection. So the call has to be taken by the House.
Right. More than 200 amendments I'm given to understand, and 170 proposed by the chair in PB Chaudhary, and earlier it was Meenakshi Lekhi. But I want to understand the contentious clauses. Clause number 57 is a issue of contention. Clause number 35 is a cause. There are a few MPs who have already written their notes of dissent. We are given to understand that you were also somewhere sitting on the fence. But where was your, did you have any issue with the bill?
No, so my issue with the bill, which I had spoken quite elaborately even outside, and I've written extensively on it, is the need for having a state-level data protection authority. So that is not really one or two clauses in the bill, but the entire architecture of the data protection authority as conceived in the current bill is something which I feel, my personal feeling, and after having so many years in the bureaucracy, I think that there are two aspects there. One, that it becomes entirely a central government's decisions, not a central government, central body's decision, which will be overriding the interests or the events that arise in the states and in the districts. And mind you, it also includes both manual data as well as electronic data. So manual data is generated largely in the districts, in the taluks, and in the panchayat. So I think that a state-level data protection authority in line with the Consumer Protection Act. The Consumer Protection Act, similarly, it protects the consumer. And here data principle and data is considered as an asset, more or less similar footing. Even the Right to Information Act, RTA Act, has a state-level authority. So I think this bill's architecture should have been designed in that manner. And countries like Germany have this. So it's not that. So this is the view. And our final view will be given when we have time till tomorrow to take a call on this. There is discussions I'm having with people within my party as well as within the state government. And even you see the state governments of Karnataka and Maharashtra, when we visited them, they also made similar pitch for a state-level data protection.
So, but that's not part of this architecture, is what you're saying. So, is that going to be a separate exercise? Would you want some assurance on that front, or can that be incorporated as part of this bill?
See, so that exercise has to be done by the government, and the changes, if it is, it can be done easily. Then that exercise they have to carry it out. I haven't myself carried it out, but I was having a look at the RTA Act. I was having a look at the Consumer Protection Act, the new act which got introduced last year, and in fact we in the Parliament approved it. So there it is a part of the act to have a state commission or a state authority. Here it is no such mention. So I do not think it could be just one or two provisions which could be changed. It might require a complete change in every section or critical sections of the bill. So that exercise has not been done by me. I am not aware if the government has done it and what is the kind of rigor that would be required for doing it. But that exercise, in my personal opinion, is called for.
As far as clause 35 is concerned, where we've seen Congress leaders like Jairam Ramesh and also Trinamool Congress leaders like Derek O'Brien, Mahua Maitra, they've already expressed their dissent. Manish Tiwari has also said that cannot be unbridled freedom that can be given to central agencies in terms of access of data and what they can do and how they can act. There have to be some checks and balances that have to be put. So what's the larger view, and finally what has been arrived at?
See, ultimately, I think we have to remember that this bill has come out of the Puttaswamy judgment. Puttaswamy judgment was a decision being taken on UIDI Aadhaar. It was government data. It was a government data fiduciary, if you use the language of the Act. Now, Section 35 are reasonable restrictions, are in the nature of reasonable restrictions or exemptions that have been carved out in the Act. The law, as enunciated in the Puttaswamy judgment, is very clear that whatever restrictions you put in, it has to be proportionate, it has to be reasonable, it has to be fair, it should be serving the purpose, it should have a nexus with the purpose for which it has been brought out. So it has to be as narrowly defined as possible. I have not yet seen the dissent notes. I believe they have put it on their Twitter handle or somewhere, but I have not yet seen them. But this discussion was held elaborately again in the committee. I can't divulge what was the point of view of everyone. I don't know, do I remember, because it was held long ago. But I can only say that if currently the way the bill, the Section 35 is structured, it gives the impression that the Supreme Court's ordained, exemption criteria that it should be prescribed by law. It should be proportionate. It should be legitimate. All these. This test actually will ultimately be done by the court itself, maybe in a judicial review if anybody approaches the court. But it would actually be, I'm sure, I have a feeling that it would actually go to the court. As it stands now, it appears okay to me, because I think some restrictions are necessary. But how narrowly to define it is most important, because there is a provision there which says that the central government will ultimately come out with notifications from time to time, giving exemptions to certain category of people for certain purposes. So that would actually show the actual intent of the implementation of Section 35.
Because there were demands that every time something like this has happened, the parliament should be apprised, and then there's the counter that if it's a matter of national security, can you actually make it public? Because if it is tabled in parliament, and if the parliament knows, that means the public would also know. So that's one aspect. The other aspect is about fines. It's about what should be decided, finally arrived at. Clause 57 was also a cause for concern.
No, to Clause 57, the way it was introduced initially in the bill, had very fixed percentages mentioned in the Act itself. And this kind of mention has been made in the EU GDPR as well, the European Union's data protection regulation. Since our bill has borrowed heavily from the EU GDPR, I think that was mentioned there. Currently, whatever version will finally get introduced, we'll have to wait and see as it comes in the parliament. But there has been a thought that maybe it could be left to the central government to prescribe it from time to time. It makes sense also sometimes, because different category of offenses and different category of the severity of the offense would also determine the severity of the penalty. And what is severe and what is not severe could actually be decided by the central government, and it will also depend, it will be contextual to the time also. So in a way, there is a justification of giving the power to the central government to prescribe it from time to time. There is also a justification for keeping the entire thing in the bill itself, as it has been done in EU GDPR. Let us wait and see how it comes in the final bill that is introduced in the House.
Are you, right now, given what is the deliberations, given what has happened, are you inclined to support the bill?
Sorry?
Are you inclined to support the bill?
I think it's not a question of me personally. The party will take a call once the bill is introduced in the House, because you have to remember, I think this is the most important thing which I want to highlight in this show, that the deliberations of any standing committee, parliamentary standing committee, or a joint parliamentary committee such as this should be non-partisan or bipartisan. I mean, a discussion is basically not taken on party lines. The support or opposition to the bill would come only when it gets introduced in the House. And that is how it becomes content rich. It becomes, it goes above the party lines, and a better version of a bill or an ordinance, which is meant to be a bill, comes to the House. And the House then takes a position. So I think our party will take a call once it is introduced in the House. And I must reiterate that there are just not 2 provisions in the bill. There are 98 provisions and 99 provisions, and a lot of it has had tremendous amount of bipartisan support within the committee itself.
My final question, Amar Patnaik ji, how critical, how important is this bill for us as a country? Because a lot of people are not aware the threat that the future wars could be on data, the future colonization could be on data, and data security, data sovereignty is integral to a nation's identity and its security. So could you please underline that for our viewers?
You see, with my limited, experience in the parliament so far, just 2.5 years, I can say that as a citizen, as an informed citizen, who has had, experiences also with the executive, with the now with the legislature, I and also I'm a lawyer, so I know what is the law. I can say that this particular bill or act provision, when it gets passed in the parliament, will become one of the most significant legislations that democratic India would have had in the country. Why I say significant is because this is not merely a question of regulating data or the flow of data. What the bill has assumed, why the bill has assumed such significant proportions or importance is because of the Supreme Court order, which said that the data privacy, informational privacy of citizens is a fundamental right. Now, since it is a fundamental right, it is now the constitutionally guaranteed right to every citizen of India, which will be protected by the constitution and therefore the courts of this country. It is not for the executive or the central government to protect it, or it is for the legislature to protect it. It is constitutionally now guaranteed, and therefore it will have overriding effect on many other data fiduciaries, whoever handles data. It could be the Chief Election Commissioner, it could be the CAG of India, it could be the entire central government, anybody. So you can imagine, or all sectoral regulators, the TRAI, the RBI, which is an old act since 1934. And so all these will come under the ambit of this. And therefore, I have written an article in this which said that my personal view was to have a constitutional entrenchment for this data protection authority, because this bill has the nature of a fourth regulator, fourth institution regulator. That means it is basically protecting democracy, rights of citizens, and that is how the Supreme Court has made it out. And therefore, it is so important, and it is therefore equally important, which is also provided in the Act, to make people, citizens who are called the data principals, aware of the value of their data. And it is not just electronic data. I am repeating the cost of repetition. I would like to say that the data which is generated in the Gram Panchayats, in the rural areas, in a census operation, any kind of activity, they are also under this ambit. And that data breach would also be tried in the court of law. That is guaranteed. That particular citizen also has the fundamental right not to have his data breached, or not to process his data without taking his consent.
True. So the significance is huge. Let us hope that political parties will rise above their politics and put the interest of the country when this is tabled in parliament and debated. Amar Patnaik ji, thank you very much. I thought you had a closing comment to make there, so I waited for you to share your thoughts before I would say thank you to you.
Thank you. Thank you so much. Thank you.
Thank you. Thank you.
Thank you. It's always a pleasure interacting with you.
Thank you, sir. Thank you. Pleasure is mine. Thank you.
Bye. Bye.